We're going to call a meeting to order. We have a problem in that we do not have a quorum. As a result of that, we're not going to be able to vote on any matters. We really will not even be able to approve the minutes from the last meeting. But I think that everybody is in the same position that I was in this morning. I was over halfway down here when I got the call. So I think the decision was made, and I did have Ms. Beebe contact Chair Pinkins to see what he thought we should do. And there was a feeling that we should go forward. So here we are. We'll keep it brief. There are some matters that we can discuss. Do we have Ms. Lewis on Zoom? Am I all right?
Yes, Ms. Lewis is present on Zoom.
Okay. Well, I'll tell you, one of the things that we can do to start off is let everybody know where the subcommittee is that's reviewing our ethics ordinance to see what, if any, changes should be made. We were working from a red line copy that Dr. Carnell's group put together. It's my understanding some time ago, maybe a year or two ago. No action was ever taken by the commission on those proposed changes. So what our group has done is we've reviewed those changes. And in many instances, I think really in most instances, we voted as a subcommittee to approve the changes that were suggested by Dr. Carnell's group. However, there were some that we didn't adopt, and some that we adopted, we made minor tweaking or changes to. At our last meeting, which was last week, we made headway. We completed that area of our work. We completed the red line copy, and we made changes to that. We have two other matters that are very important that we have yet to consider. I believe that we're going to need at least another meeting or two of the subcommittee to get a final draft to submit to the board, the full board. Those concern a provision that would provide an opportunity for a member of the public, whether they're a respondent or the complainant, to make a motion, a request that a board member be disqualified from their matter for whatever reason. That's sort of thing that happens in court proceedings all the time. We don't really have a provision or a mechanism for that right now. So what we did at our last meeting, we agreed that I would work with Mr. Longstreet to come up with a draft and then submit it to the subcommittee. Again, I want to stress it's not ready to be submitted to the board yet. And we've done that. I sent him a draft, and we talked back and forth earlier this week, and we agreed that the draft that we have now is something that we could present to the subcommittee at our next meeting. And I'm going to afford Mr. Schaefer and Ms. Lewis and Mr. Longstreet to comment on the status of things now as well. But that's my understanding of that. Now, the big remaining issue that we have yet to discuss and decide, and it's something that we could certainly talk about today. Yes. Oh, okay. Okay, very good. I apologize. We didn't do a roll call. So can you do the roll call, Ms. Beebe?
Mr. Young is excused. Mr. Schaefer? Ms. Lewis is on Zoom. Ms. Hammoud?
Good morning, present.
Dr. Carnell is excused. Chair Thomas?
Present.
Mr. Pinkins is excused.
Anything else we have to do?
Moving on to the minutes.
So
Well, we're not going to be able to vote on them, so we'll have to pass on that.
per chair? So
Yes.
should we notate that we don't have a quorum? That's why we're not voting and proceeding with, okay, thank you.
So because there is no quorum today, moving on to approval of the June 8th, 2022 meeting minutes, there will be no vote, only discussion.
We're not going to be able to vote on that, to approve that. So I don't think there's really anything to discuss regarding that unless Mr. Schaefer or Ms. Hammoud disagree.
Moving on to unfinished business, item 1, update from the subcommittee, amendments to the ethics ordinance.
All right, well, that's where we were when you were kind enough to remind us that we hadn't done a roll call. So I'll get back to where I think we're at. Then I want to turn the floor over to Mr. Schaefer, Ms. Lewis, and Mr. Longstreet. I think that the most significant thing that the subcommittee has yet to talk about, we sort of left it for last. I don't know if that's just the way it turned out or if that was by design in all of our minds, but it concerns the ability of of the board to investigate matters. We have no investigative budget. We have no investigative resources. And there was discussion at prior meetings, I believe it goes back to May or June, that we need to talk about that. We need to consider that, because when a case comes along that requires us to investigate matters, to look into matters, maybe to have witness statements taken before people are called in to testify before us. We really do. I don't know if there are other boards that don't have resources, other investigative boards that do the type of work that we do, that don't have resources for that. I guess the only resource that we would have right now would be Mr. Longstreet in his office, but we wouldn't want to put him in a conflict. I mean, if he, for example, if we asked him to interview a witness, how do you do that? How does he do that? If he called somebody up on the phone and it wasn't significant, I guess he could report back to us, but then he becomes a witness in the case if the witness recants or changes their testimony. So it's kind of a complicated area. And I think from talking to other board members that have been around longer than I have been around, and even the discussions at the meeting, I think the right case has not really come around that compelled the board to grapple with that. I think everybody in past years just said, we don't have the resources for it. We got to depend on the person that filed the complaint to go out and do the investigation, to give us the paperwork, to give us what's needed, and then to depend on the respondent when they supply their response to give us any witnesses named that they believe would shed light on the investigation. And I think that's unfortunate, because our role as a board enforcing the ethics code is to come up with fair decisions regarding complaints that are filed. And we want to be objective, and we want everything above board. We're subject to the Open Meetings Act. We want transparency. So it's going to be a very important area for the subcommittee to discuss. Unfortunately, Ms. Amoud, I believe you're the only member of the board here that's not on the subcommittee. So if there's anything you would like to say to address that, I will tell you, I'm not speaking for the entire subcommittee, but I think that there is right now a consensus that we have to be discussing this. This is an important area. Is there anything that you would like to add concerning your thoughts?
No, I mean, you addressed like the issues that came up before, and we relied on the person who submitted the complaint, and we relied also on the respondent, and to be able to provide the information. And we conducted a hearing to be able to see, both sides, and before we can determine, the next, move.
Yeah, one of the things that we're talking about, we discussed at one of our prior subcommittee meetings, was the whole concept of people appearing before us and giving testimony when they're not sworn. I want you to know, I'm not saying that that doesn't happen in any other setting, in any other investigative setting, but if there is, it doesn't come to my mind, and I've been around for a long time. I think that normally when individuals contemplate calling somebody as a witness, you expect, I think everybody in the public expects, and the people involved in the proceeding, that the person is going to tell the truth. And I think an oath enforces that. I think it's a sobering step in the process. So that's going to fall hand in hand with the whole concept of investigative authority, because we don't have any of that right now. So I spoke to Mr. Longstreet, I believe on Monday of this week, and I think that he and I were in agreement that the subcommittee needs at least 1 or 2 more meetings, possibly 3. And our next meeting is on August the 25th. And one of the members, Mr. Schaefer, at the last meeting indicated that, what he wants to do before the red line draft with all of our changes, where we adopted those of Dr. Carnell's group, and those changes that we're making new. He suggested that we as a group look all that over, a completed product before it's submitted to the board. And I will tell you right now, I thought it was a great idea. Ms. Lewis thought it was a great idea. So that's why it's going to take us a couple more meetings to get through our work. So with that, what I would like to do is ask Mr. Schaefer if there's anything he wants to add, Ms. Lewis if there's anything she wants to add, and then we'll turn the floor over to Mr. Longstreet. Mr. Schaefer, anything that you would like to add?
Okay, now, okay. Let me start. The only thing I would add is that we might want to be proactive to determine what, if any, funding we might be able to get with regard to any investigative ideas that we come up with, because that's going to require, as you indicated, somebody outside the committee to do any investigation that we might want to have. So I'm not sure who we would talk to with regard to that issue, but I'm just putting it on the table so we can at least think about it and other members can think about it, and we might get some guidance from somebody from the county saying, here's who you need to go talk to get funding. And when we get together and talk as our subcommittee, figure out what kind of budget might be in play at that point.
Excellent point. Well, we're fortunate enough to have Mr. Joseph Slezak here today. I don't know if there's anything that you could do to shed some light on the matter that has been raised, but obviously, if we're going to have investigative authority, there's got to be resources.
Well, actually, this is Joe Slezak, and I'm legislative and policy analyst. I really have to defer to Felicia Johnson, who is commission counsel. I really have to defer to her.
Is she here today? Oh,
yes, she's
good.
at the
Excellent.
at the podium.
Sorry, I didn't see you, Ms. Johnson, approach the podium.
Good morning. Through the chair, Felicia Johnson, attorney for the County Commission. This board is free to make a request. The county and specifically the commission is very aware that you need budget and there is funding. Obviously, you have an attorney that's being funded. There was previously a request for an inquiry regarding investigator and funding for that, which was not funded at the time. We can have further offline discussions regarding this board making a future request. But that is something that's come up in the past and it was discussed and reviewed. Again, that's not to say that this body couldn't make another request for that to the county. And again, we can discuss the details of how to do that offline.
Okay, very good. So we don't have to do that today on the record. We can contact you when the time is right, and perhaps you can fill us in on how to pursue that. Thank you, ma'am. Thank you very much. Excellent point, Mr. Schaefer. Anything else, Mr. Schaefer? And then we'll turn the floor over to Ms. Lewis, who is joining us by Zoom.
Through the chair.
Well set.
Through the chair, per the Open Meetings Act, members have to be present in person in order to participate in discussion.
Well, I knew that they couldn't vote, but in the past, look, I'm going to abide by whatever the rule requires, but Ms. Hammoud, you've been around a while. Are you familiar with that? We've only had to deal with this since COVID, but are you familiar with that provision?
I mean, I'm not an attorney, but I would assume a public comments is available to everybody, whether they're on the board or not. So, I mean, maybe we can include them part of that at least, but they should be able to speak even if they are on Zoom and they're not here. But again, with COVID and everything else, the rule, I would, ask the other attorneys here if they have any other opinion, but that's my just personal opinion.
Well,
They should be able to speak, at least, in the discussion, not that they can vote or put a motion. I understand that.
Well, Ms. Beebe, do you have something hard and fast that you could point to today? I mean, I would like to hear from Ms. Lewis, and I think Ms. Hammoud and Mr. Schaefer and Mr. Longstreet would as well. But if you're telling me that that has not been done, but I do want you to know that in the past, since COVID, I do recall times when people were on Zoom, they were told they couldn't vote, a member couldn't vote, but they could talk. So we're just having an open discussion here. Do you have anything on point that you would be able to direct us to that would say that she couldn't speak? Just Ms. Johnson, just 1 second.
Through the chair, I defer to Commission Counsel Johnson to clarify.
Okay, could you clarify that, Ms. Johnson?
And I'll say that Ms. Spivey is getting that from me based on my legal opinion. We reviewed this obviously on behalf of the commission and other boards. I don't want to step on Mr. Longstreet's ability to advise this body, but under the Open Meetings Act, you cannot participate. That includes discussion and voting. Now, there is currently, someone has introduced legislation to allow for participation via Zoom. However, that legislation has not been moved or adopted and is still in the process, but the state is at least looking at that portion. Someone has introduced that legislation, but it's still pending.
All right, thank you very much. Well, Ms. Lewis, I need to make a decision on it. And in light of what Ms. Johnson just said, I don't like doing this, but I think that what Ms. Spivey and Ms. Johnson are saying is that you can't participate in the meeting even though you're available on Zoom. And I apologize.
Oh, no problem.
It is a
Thanks for
discouraging
the clarification.
All right. Well, I'll tell you what, now, Mr. Longstreet, we can't hear from Ms. Lewis. What would you like to add, if anything, to what Mr. Schaefer and I have said about the subcommittee's progress and where we're at?
Okay. All right. Thank you. I believe that the subcommittee has made great progress in making corrections and or deletions to the ethics ordinance. And also, I also agree with all the other comments made by Mr. Schaefer and Mr. Thomas. I think we should continue moving forward in the fashion that we've been moving. I don't have anything else to add.
Ms. Hammoud, do you have questions or comments?
Per chair, just like from a process standpoint, because we don't have a quorum and this is just for discussion only, we're not putting like a motion. I understand if we have a motion and we're doing the discussion, like that's not allowed. Again, I know the rules are changing as we speak, but just maybe for future, if we can get guidance even for future meetings, because like this meeting right now, although it's on record and it's public, but it's not an official meeting because we don't have a quorum. So I would be curious for the next meeting to get maybe a legal opinion to like how to conduct that based on the Open Meeting Act without like limiting the people on Zoom to participate.
Oh, your point is excellent. And let me just tell you, I would hope that something like what happened today doesn't happen again, because in the past, what Chair Pinkins has done is when you know you're not going to have a quorum, the meeting is canceled. But all of us, yourself, me, Mr. Schaefer, Mr. Longstreet, we all learned about this morning, this problem this morning when we were on the way down here. I was over halfway down here myself, but so we decided that we would meet and discuss those things that we can discuss. I would rather not challenge a rule at this point in time, but what you're raising is very important, and that is what happens in the future when this occurs, or better yet, what happens when we have a quorum and we have a member, a very dedicated member who's on Zoom who couldn't attend. I think it's something that we should clear up somehow, some way. Mr. Longstreet, you're our counsel. I have great respect for Ms. Johnson and her role. I have great respect for Ms. Beebe and the role that she plays. But I will tell you what, I would like, I'm going to request that at some point in time, you give Chair Pinkins and all of us your opinion on what we can permit when a member is on Zoom regardless of whether we have a quorum or not, because that may happen. I could tell you right now, if I was away on vacation, but I had the opportunity to see what was going on. I know I can't vote, but maybe I could be able to participate. But for today, what we're going to do, since we don't really have a whole lot of important issues in front of us, we're going to go with what Ms. Johnson and Ms. Spivey believe, and we'll let it rest there. But I would hope that you'll be able to get back to us on this, maybe as soon as the next meeting, if not the next meeting, the one after. It's something that we should revisit.
Respectfully, I can give you that answer now.
Okay, give
But
it
if
to me now.
you prefer a written response, I would appreciate you allowing me to do a written response, even
Well-
though I know the answer now.
Well, I think we should, especially in light of the fact that we don't have a majority of our group here. So I think that would be important. But for today, the only thing I'm saying, we're not making a decision. We're just saying for today, we're going to rely on Ms. Johnson and Ms. Beebe.
I would have to say, in just being transparent and honest, I would have to concur with Ms. Johnson's decision at this time.
Okay, very good. Well, let's have it in the future. Let's
But I'll
have
put it
the
in
future.
writing to be sure, because I know there's been some discussion. I know there's current legislation, and I know there's a opinion written by the Attorney General on this particular issue. So I would like to delve into it further, but this discussion has been had between myself and Ms. Johnson about 2 months ago in reference to this. And I did have to look at the Open Meeting Act to determine, because I also believe that they should be able to speak even though they're on Zoom. I was forced to do the homework on that issue based on the fact that Ms. Johnson brought it to my attention that we probably couldn't have members participate on Zoom. I did the research myself, and as it stands currently, there was a legislation that was temporary that did allow for persons to participate on Zoom, but I believe that ended, sometime in February or March. Now all persons have to be, pursuant to Open Meetings Act, all persons have to be present at the meeting in order to vote and or participate in discussion, as I believe it currently reads, but I know there's a lot more discussion. There's a lot more writing on that particular issue. So I would really like to delve deeper into the issue and present something to the board in writing so we know officially. But as of right now, according to my current understanding of the reading of the law, I must concur with counsel, sister counsel.
Well, I tell you what, that's excellent. We'll get it in writing from you, and we'll discuss it at a future meeting. Perhaps we could even discuss it at our next meeting. The only thing that I would say would be this. If that is in fact the law, we follow the law. That's as easy as that. Nobody's going to take an issue with that. But the thing that I would find unfortunate about that personally, it would prevent members who can't be present from looking in and chiming in on certain issues when members of the public can do it at the end of our meetings. They can do public comment. But the law is the law. That's what we're here to follow. So we'll let that rest. So Ms. Lewis, after that long discussion, I think where we're back to is you can't participate. You can't talk. So have we covered in Mr. Schaefer's mind and Mr. Longstreet's mind, have we covered everything that we needed to talk about regarding a subcommittee update?
I would say yes.
Okay, very good. Well, I guess that the other thing that's on the agenda is the question that has been raised by Reverend Taylor regarding a complaint that he filed and letters that the board sent out. You may recall that at a prior meeting, actually 2 prior meetings, we discussed what was going to happen with Reverend Taylor's complaint against the Wayne County Sheriff's Office regarding individuals from pastoral groups or whoever going and counseling with and speaking to and preaching to individuals who are locked up in a county facility. And the board made a decision that wasn't the substance of his complaint, and I'm summarizing it greatly, did not fall within an area where we have authority to review the subject matter of the complaint. So 2 letters were prepared. One was prepared to be sent to the Sheriff's Department. One was prepared to be sent to Reverend Taylor. Reverend Taylor's letter, it's my understanding, Mr. Longstreet, that letter went out?
That letter is out.
And the letter to the Sheriff's Department, that went out as well. Yeah.
That letter has been sent to the Sheriff's Department as well.
Well, subsequent to those letters going out, I know that Mr. Longstreet received a call from Reverend Taylor, who is here today, and you'll be able to speak during the public comment if we get to your issue that's before us today. But Reverend Taylor called Mr. Longstreet, and subsequent to calling when he called Mr. Longstreet, he requested a copy of the letter that was sent to the Sheriff's Department. That was how the issue arose. He wanted a copy. He wanted to see a copy of what went to the Sheriff's Department because he had seen all of our discussions on Zoom. He watched them. He would have seen Ms. Hammoud making a motion to have certain language included in the letter to the sheriff, certain language in the letter included for Reverend Taylor. So he saw that, and what he did when he contacted Mr. Longstreet and requested a copy. After that, he had a discussion. He didn't get satisfaction from that discussion. I want to make clear, both letters went out just to the individual addressee. The letter to the Sheriff's Department went out to the individual who the complaint was filed against. The letter to Mr. Reverend Taylor went out only to Reverend Taylor. No courtesy copies were given out. Now, what I would like to do before we even get into that issue is raise this question, because we have a quorum problem that we didn't know we were going to have here today. I believe that this is an issue that may need to be decided by the full board. And the question, as I see it, is this: when we send a letter out concerning a complaint, in this situation where we're not going to take any action, and we send a letter out to the complainant, and then we send a letter out to the respondent, the individual that the complaint was filed against, we have to decide what has our past policy, if any, been. I don't know that there's a policy. I certainly haven't been able to find one. And then if there is not a policy, we need to decide what the policy is going to be in the future. Now, when I talked to Mr. Longstreet, one of the things I said is I'm familiar with a lot of different criminal agencies. I do that type of work, and disciplinary agencies. And the example I would like to give would be at the Attorney Grievance Commission. I'm very, very familiar with how that agency operates when a complaint is filed. If a person named Jane Smith files a complaint against a lawyer, and the Attorney Grievance Commission makes a determination that they're not going to take any action on it for a variety of reasons. They're not going to take any action on it, and they may even give a little advice. A civil lawsuit may be involved, but that's not something we do. So you've come to the wrong forum. They send a copy of that letter to the complainant, and the respondent lawyer gets a copy of that very same letter. Now, on the other hand, if that agency makes a determination that the lawyer has done something wrong and they want to caution that lawyer, or the next step up would be an admonishment, that letter goes out to both parties. So because of transparency and sort of what I'm familiar with, I feel that it's something that needs to be discussed. I don't know the reason why we wouldn't give the letter to each party. I honestly do not know what the reason for that would be or the rationale would be. But with that said, and the issue framed, I really am not certain that we can decide this issue today. We don't have a quorum. And if we're going to be making a judgment call on it, and Reverend Taylor, with all due respect, I've seen you back there. I've seen you raising your hand. We're just not ready for you yet. What you need to know is, I don't think that this should be done on an ad hoc basis. I don't believe, for example, that we should make a decision concerning this complaint and the Sheriff's Department and Reverend Taylor I believe that we should have a policy. If we're going to close a file because we don't have jurisdiction, we don't have authority, both parties are going to be notified. The complainant is going to be notified, the respondent is going to be notified. So my problem is here today, I don't really believe that, I'm not even sure that we could make a decision just on this one complaint that's before us today. But I'm going to, and this falls under category number 1 on page 2 of the agenda. I really believe that in my role here today, and I want to hear everybody out, but my belief is we have to table this to the next meeting. And I know that's not going to make Reverend Taylor, I know that's not going to make him happy, but we've got to do what we've got to do. And we've got to always make sure that what we're doing, first of all, we have to make sure that it's the right thing. And then we have to make sure that for appearance's sake, it appears to be the right thing. And I know that Reverend Taylor is a very articulate man. I've spoken to him. And I know that he will understand this matter being put over until we have a quorum. So we're going to get to you, Reverend Taylor. What I would like to do now is I would like to open the floor for discussion by Ms. Hammoud and Mr. Schaefer to hear what your thoughts are as to whether we even have the ability to discuss this and not discuss it, decide it today.
I agree with you without a quorum. I mean, I'm hesitant to do anything, take any action per council's, opinion and advice. We can't do anything.
Mr. Schaefer?
I agree with that. I think the Open Meetings Act would preclude us from making any decisions.
Well, I think that what we're going to do, Ms. Hammoud, Mr. Schaefer and I are in agreement on it. We're going to table this discussion. But one thing that I would say is we'll put this on there. And I'm just suggesting this, Ms. Beebe, how does the wording make its way onto the agenda? Could I ask that question? Because I think what I would like to do would be to work with you for the next agenda to flesh that out a little bit. So this says properly submitted distribution of attorney opinion letters. These really aren't opinion letters. These are closing letters. So when you do the agenda for next month, could I please ask that you, under this item number 1, this isn't distribution of attorney opinion letters. This is really a question of whether the complainant gets a copy of a closing letter that goes to the respondent and whether the respondent gets a copy of the closing letter that goes to the complainant. I really believe that that's how it should be worded so that all of the members who aren't here today and aren't participating are really aware of that category. Okay. All right.
Yes, Mr. Chair, that change will be made for the next agenda. Thank you for clarifying.
Okay, thank you very much. Now, Ms. Beebe, we have Reverend Taylor here today, and he wants to address our group. My question would be this. Should we put that over to public comments under paragraph F? Or we should put that over? Okay, very good. All right. Well, then with that said, Ms. Hammoud, Mr. Schaefer, anything else we need to discuss here today before we get ready to close the meeting and open the meeting for public comments?
Oh, not in my opinion.
Ms. Hammoud.
Yeah, one thing about to go back to previous item about the subcommittee work, what you brought about the opinion and closing, I know like in the ordinance, because I was able to pull it, there is a clear instructions to like the positive determination in case there is finding, like when we don't dismiss it, to who we distribute that opinion or determination, I should say. So maybe like in your work, since in August you want to have that discussion, you may want to also add that to say in case we have a dismiss like this, who like with that determination also, how can we like publicly have that available as well? Okay.
Yes, Hamud, that is an excellent point, as always. Could I ask this for Ms. Lewis's sake, Mr. Schaefer's sake, my sake, and Mr. Longstreet's sake? Tell us what page you're at and what paragraph.
This is on page, well, in mine, like it says page 15.
Okay, but what subsection? What's the title it's under?
So this one in hearings. Oh, okay, so you have, probably mine is printed with different page numbers then?
Yes,
Okay, yeah, it's part of the hearing before standard of review. It specifically talks about, those items.
Mr. Longstreet, do you know where it is now so that we can categorize that as something we're going to discuss at our next meeting? Okay, very good.
I do know what she was referring to, and there speaks some operating procedure in regards to when the board is going to take action, how much time when I have to send a letter. I have to send a letter to the respondent. If the board decides to take action on the matter, I send both the complaint to the respondent. The respondent has a certain, I think, 21 days to respond, and then we send their response to the complainant. So there is some exchange of letters in regards to both parties when the board decides to take action. However, the statute is silent on operating procedure when the board decides not to take action. So I would just suggest at our next subcommittee meeting that we get some clarification in regards to the operating procedure, because I got caught up early on in regards to the operating procedure myself, because it is the operating procedure and the statute are two completely different things that tell me to do two completely different things. And I think we need to get clarification on that. So I think at the next meeting, our next subcommittee meeting, we need to talk about operating procedure and getting some clarification on that as well.
Well, I'll tell you, for the benefit of Mr. Schaefer and Ms. Lewis, I will tell you right now, we've hit on something here, and it would be my position that at our next meeting, we definitely want to include that as a proposed change. The board is still going to have to take it up at its next meeting, the full board, because we got to decide what we're going to do in the interim. But what I would say is this: I think what we have to do is we have to decide where early on in the ethics ordinance, where it talks about the complaint and the complaint being disposed of, we have to, I think, come up with a sentence or two that says when a complaint is closed, the letter is sent to the respondent, a letter is sent to the complainant, and if the letters are different, they're exchanged. Everybody gets a copy of it. That's called transparency. That's good. So we agree on that. But Mr. Longstreet, we're going to depend on you to frame that issue for the subcommittee and come up with perhaps a sentence or two. And even more important than that, the location in the ethics ordinance, because it should appear early on. It shouldn't be under hearings.
I would agree. I think it should go early on in regards to when we receive response or when we receive complaints, how much time we have to respond to that complaint, how much time we have to send the information back to the complainant if the board is not going to make an action on it. The statute is silent on the operating procedure, so I think yes, most definitely that's something that should be discussed, and I'll most certainly draft what I believe should be placed in the ethics ordinance.
Excellent. Very good. Thank you very much, Mr. Longstreet. Well, Ms. Spivey, that brings us to subparagraph E. We can't vote on anything, but subparagraph E of the agenda talks about such other matters as may be properly submitted before the board. Ms. Hamud, Mr. Schaefer, anything else other than what we've talked about that you would like to see discussed today? Nope. Okay, and I don't have anything else. Well, can we move to public comments then, Ms. Spivey?
Yes, public comments are open.
We are moving to public comments, and Reverend Taylor, if you're going to address us, which I believe you are, could you please step to the podium? Please identify yourself.
Thank you. I'm Reverend John W. Taylor of Evangel Association of Churches and Ministry in Roseville, Michigan. Good morning, Wayne County Ethics Board members.
Good morning, sir.
Chairperson Thomas and Attorney Longstreet. Thank you for allowing me this time. I know in your earlier comments, you were giving a general idea of what the complaint was all about, but to keep it as simplistic as I can, basically, I've been volunteering my time, my energy at the Wayne County Jail for over 35 years with other volunteers as well. We go in and we minister to the inmates at that facility. The problem was this year, they came up with some new documents and forms that they wanted us to complete in order for us to go into the jail. I don't have a problem with the documents until they ask us on this certification. I hereby certify that I'm familiar with the contents of the security addendum, including its legal authority and purpose. That's one. Two, the NCIC 2000 operating manual. That's two. Three, the CJIS security policy. Four, Title 28 Code of Regulations, Federal Regulations, Part 20. And I agree to be bound by these provisions. You have to give volunteers this information for them to peruse over them, to find out what are they bound themselves to. And this wasn't done. That was my major issue for filing this complaint. If you want us to be bound by these issues, show us so we can read, understand, ask questions before agreeing to be bound by them. Attorney Longstreet sent me a letter. I got it about less than a week ago. Rare Whidden, cordial letter. I appreciate the letter you sent, Attorney. However, I had questions in the letter. Basically, were about 3 or 4 questions that I wanted to address. First question has to be, it states the complaint does not fall within the jurisdiction of the Wayne County Ethics Board. I mean, that was clearly stated in your last meeting, which I was able to observe myself. And it was saying like was the consensus that this does not fall under your jurisdiction. I personally asked Attorney Longstreet over the phone, well, whose jurisdiction does it fall under? He said the voters. I asked the same question to you, Attorney Thomas, over the phone. Whose jurisdiction does this fall under? The voters. Now, in a case like this, what can the voters do? I'm not asking for the sheriff to be recalled. I'm just asking him to deal with the procedure issue. What can the voters do with something like this if they're the person who he's under?
Well, I don't know. I'm telling you, you got the answer. You got the answer from me that I was able to give you during that conversation. I do not know of anybody that would have jurisdiction over an elected official and the decisions that they make regarding the operation of the jails in the county. I don't know of anybody else. And I want to tell you, I don't think that there's anybody else. So when Mr. Longstreet and I indicated to you that the decisions that he makes, that the sheriff makes, are being made as part of his elective authority and duties, that's about it. So we're not here to expound on that today. I just want to tell you this. First of all, I want to tell you that public comment is limited to 3 minutes. And,
okay.
I mean, we're going to give you a little extra time. You're dealing with some patient people. Not much, but we're going to give you extra time. We're really not here to answer or expand upon that letter. What I do want you to know is that was an important letter. And you said that you watched the last meeting on Zoom. You said that you took part in that by watching it on Zoom.
No, sir, I did not. I saw the archive copy of it. I didn't.
Okay, I apologize then. I thought you told me you watched it or you saw it, but at any rate, the bottom line is this: we spent a lot of time discussing what the letters would contain. The letters had to be approved by Ms. Hammoud, who made the motion. Myself, as I'm vice chair, but I was acting chair at that meeting. We approved it. We were careful on it. We're really not here to reevaluate the decision that we made, but it's enough for you to know, and I hope you understand, I do not believe that there is anybody outside of the sheriff's department that has the right or authority to take a look at the procedures that they employed. Now, I am going to ask Ms. Johnson a question. And if she has to step up, I'm going to ask that you step aside, but we're not there quite yet. Ms. Johnson, may I respectfully ask you a question regarding the sheriff's department procedures and whether there is somebody, I know that in the city, they have what's called an ombudsman. And in the city of Detroit, if you have a complaint if a person has a complaint regarding how the city operates, you can complain to the ombudsman. I don't know how effective it is, but it's a mechanism that one can utilize. Does the sheriff's department or the county have anything? What as I understand what Reverend Taylor is complaining about, what he's complaining about is the fact that the sheriff's department said, if you want to be able to come in and preach and teach and counsel with inmates, you've got to be bound by these documents, but he doesn't have access to the documents. Is there anybody that he can go to with his concern that he's being asked to be bound by some documents, the requirements set forth in certain documents, but he don't have the documents. He don't have access to them.
Through the chair, again, Felicia Johnson, attorney for the County Commission. So you are correct. The sheriff is a separately elected official. He has statutory duties and he has a right under statute and legislation to run the sheriff's office. So unlike the city where you may have appointees and, the city government may be able to appoint an ombudsman or someone to overlook those, we do not have that in the county. That being said, could the county commission make a general inquiry of our counterparts over in the sheriff's office to try to get further clarification of this matter? We can and will do so just to see if we can get clarification.
Could Ms. Johnson, or could I ask this question? You are always so helpful. Would Reverend Taylor be able to contact your office to find out how he can pursue this through the county commission?
And I'm not certain, and I don't want to give the false impression that the county commission can force the sheriff or we have
No, I
oversight
don't.
over the
No.
sheriff. But could, again, on behalf of the county commission and all the commissioners, could we make a general inquiry of the sheriff's office to see what information we can get to see if there's some resolution or understanding? I think that's fair and we can do that. And I will speak to the Reverend about that after the meeting.
Oh, thank you very, very much, Ms. Johnson. Thank you. Now, Reverend Taylor, we've accomplished something here today regarding your first question. Now, I did caution you that public comment is limited to 3 minutes, but we're going to give you some more time, but not unlimited. Is there anything else that you would like to say? Because so far here, what we've accomplished is you've got Ms. Johnson saying that she'll see what she can do. She's going to talk to you afterwards and she's going to see what she could do.
Okay.
Okay?
The next question has to do with the attorney's letter that the ethics board intends to address these concerns with the Wayne County Sheriff Department. My question is, how can the ethics board know that they're going to follow these recommendations that you're giving to them?
Well, we don't know. Okay, I can handle that. I don't need to open that for discussion. I'm going to handle that. We don't know that. What we did is we drafted a letter, and depending on what's done at our next meeting, you may be receiving a copy of that letter. Chairman Pinkins will be here, who will hopefully have a quorum, and we'll be able to decide the issue about who gets copies of our letters when we sent them out after we determine we're not going to conduct an investigation. Okay, so you'll get a copy of that. So I'm able to take care of that. You just have to be patient. You see what happened here today. We don't have a quorum, and the 3 members that showed up, we didn't find out that there wasn't going to be a quorum until about 20 minutes to 9 when we were all, some of us were here or very close to coming to the meeting. So you've got to be patient. And if you can do that, you may be able to get a look at what Ms. Hammoud and I, on behalf of the board, drafted and sent out. But that was a board letter that was approved by the board. What we told you, the board decided that as a group. What we told the sheriff, the board decided that as a group. So let's move on to your next question. Let's try to tighten things up.
Next question had to do with the letter, knowing that I had specifically requested that from Attorney Longstreet, and also with you, I had requested a copy of that letter sent to the sheriff's office. But seeing that you're in the midst of working on that right now, I won't even go into that.
Well, let me tell you, the day I talked to you, Reverend, I want you to know this. I got off the phone with you. I had a deposition in my office I had to take care of. Lawyer came on behalf of his client. We did a deposition. That same day, before close of business, I sent an email to all members of the board and Mr. Longstreet, and I told them about my conversation with you, and I told them what the issue was. So from the very first day that I spoke to you, I put all board members on notice of an issue that you raised. And I think it's timely raised. I think we have to decide it. So again, patience, we're going to get there.
I think the only point that was kind of confusing is when I got the attorney's letter stating that a letter was sent to the sheriff's department, he did not address my original question was, could I get a copy of it? If not, say something.
Well, we've explained it as best we can. It's an issue that we don't have black letter law on. We do not have black letter law on that. So we're going to be deciding it at an upcoming meeting, the whole issue of who should get these letters. It's not just going to be limited to you, Reverend Taylor, and the sheriff's department. It's going to be a comprehensive procedure that we're going to talk about adopting.
Okay.
Okay.
Question on here has to do, attorney's statement. The board believes that it is pertinent that the sheriff's department properly notifies citizens, volunteers, and employees of all provisions they are demanding you to agree and should provide copies of such, or at a minimum, direct you to a website where those codes, statutes, rules, and regulations they require that you should comply with can be found. In other words, he was saying at the minimum, they should direct me to the website where I can have access to that information. As I conveyed to you as well as to the attorney, that particular document that they want, the NCI 2000 manual, I Googled that, and that document is 1,123 pages. My question is, with that operation manual, what part of it specifically apply to volunteers? I'm sure 1,153 pages wouldn't apply to a volunteer worker coming in there. And even on the form, they have, before we put our signature, that this is for contracted employees. We're volunteers.
All right. Well, those are points. Now, you've heard from an attorney here today that doesn't work for the board. She's not affiliated with this board. Ms. Johnson has told you that she's going to talk to you after the meeting today, and I'm going to refer to it as try to see what, if anything, she could do to direct you in a certain way to this. I don't know where, but she's going to try to help you. At the next meeting, we're going to be deciding the issue of whether you can get a letter or not. And when I spoke to you that day on the telephone, you were very respectful of me, and I think I was very respectful of you. And I told you, these aren't decisions that I can make on my own. This is a decision about who gets letters and who gets them, and it has to be decided by the board. So what I'm telling you is, we're going to hopefully Ms. Johnson is going to be able to assist you with finding answers to these questions. And hopefully at the next meeting, you'll get a decision as to whether you're going to get a copy of the letter that went to the sheriff and whether the sheriff is going to get a copy of the letter that went to you.
Chairperson Thompson, I'm very clear on that. I've moved beyond that. I'm talking specifically about the 1,153 page manual they're requiring us to go over and adhere to. And the attorney, he suggested in his letter that we should have access to that. But I'm asking, if we're going to have access to that huge document, what parts of it specifically apply to volunteers? That's what I'm dealing with.
Your question is very well phrased. You have very articulately phrased your question. What you are saying is, hey, this thing is over 1,000 pages long. Tell me the pages or the subparagraphs in that volume that I'm going to be responsible for adhering to.
Exactly.
We understand that. What I want you to understand is we don't have authority to tell the sheriff to bring Reverend Taylor in and show him the respect that he's entitled to as a minister who wants to visit inmates at the jail. Show him the sections that he's going to be bound by. But here's the but. We were fortunate enough to have Ms. Johnson here today. She hears everything that you're telling this group, and she may be able to get you some relief in that regard. I want you to know, personally, I think that if that volume is as thick as you're saying that it is, I think it would be helpful to tell people who are going to be volunteer ministers coming to the jail to preach a noble cause, to preach to inmates, what sections they're bound to. But let's see what Ms. Johnson is able to accomplish for you. At the next meeting, you'll be able to know definitively whether you're going to get a copy of the letter we sent to them and whether they're going to get a copy of the letter we sent to you. So really, the bottom line is this. You're going to have to talk to Ms. Johnson, and you're going to have to wait until our next meeting to see if you get a copy of the letter that went to the sheriff. I don't know how to say it better than that.
Thank you for your time.
You are very, very welcome, sir. You have a great day. Mr. Schaefer, Ms. Hammoud, we don't really have a meeting because we don't have a quorum. Is there anything that you would like to say regarding the questions or comments that Reverend Taylor has made at the podium?
Thank you for bringing this forward to this board. I apologize that we don't have, way to tell elected officials how to run their departments. But I just want you to know, I was one, try to put recommendation, but that's all we can do. We can recommend that public official to do something, but we don't understand all the limitation, resources, stuff like regulations that they have to deal with in order to provide you the information that you're asking. So that's why we rely on our public officials that they are helping the citizens of Wayne County, as much as they can. We did the recommendation. That's why I suggested to send the letter. So, and I'm hoping that once they receive the letter that they will try to provide you the information as much as they can. I did suggest the website, but I totally understand sometimes when you have rules and regulations, it can be, and I'm not an attorney, but it could be, hundreds or more pages. And I totally understand. Thank you for coming today to tell us, in addition to probably, if they want to give you a website, if they can also provide you the important sections or the sections applicable and appropriate for your volunteers. So, I'm assuming this is taped and hopefully maybe the sheriff department will be reviewing this. And I know Ms. Lewis, thank you for volunteering to help in this. But as far as the board, as far as I know, we had to dismiss this because we don't have the violation based on the ordinance that we're following as a board. So thank you.
Mr. Schaefer, anything?
No, I think it's been discussed thoroughly. Thank you.
Reverend Taylor, why I've tried to, if it's just a brief comment, we'll let you make it. But what I tell you is we devoted much more than 3 minutes to your public comment. But if you have something that you want to say briefly, go ahead.
Yes, Ms. Hammoud's comment saying that it is dismissed. Would this situation be dismissed even though it hasn't been resolved?
Yes. To be very frank with you,
It
yes, it was. We made a determination. Now, I'm telling you, we made a determination that we weren't going to take any action regarding your complaint, and that would be a dismissal. Yes, it would. But you have the right to be at our next meeting. If you want to be present at our next meeting, you have a right to be present. Any other public comments that anyone cares to make? Do people have the right to make comments via Zoom, or are we all finished with public comment, Ms. Spivey?
Yes, all lines have been unmuted on Zoom for anyone who wishes to speak.
Any other public comments?
I don't see any hands.
All right. Well, I'll accept a motion to adjourn.
Do we even can put a motion to adjourn?
I guess we don't. We can't vote on it. Excellent, Ms. Hammoud.
Okay, so
We
Ms.
can't
Lewis,
vote on it. Okay, well, I hope everybody has a very nice day. I hope everybody has a very nice month. Our next meeting is on August 17th. Did you have something you wanted to say, Ms. Johnson? Well, we don't have a motion to adjourn.
Oh,
We're
we'll
all
have a
going
motion to
home.
adjourn then.
Can we
Thank
say
you.
goodbye to each other on the way out? Thank you all very, very much. Thank you.
Thank you. Take care.